So here we are. We're LAWS 12066 land law yet again in week 11, and we're tackling the last topic, which is topic 10 on mortgages. But we're just making a few remarks to start with, just in terms of getting towards the end, and that the exam, of course, is 2 or 3 weeks away. And you just, look, folks, what you need to do is you just need to have steady application. Make sure you spend some time practicing doing questions under exam conditions. A little bit. I'm not saying you want to do that all the time, but just a little bit, testing what you can do in that handwritten exam under the time frame that you've got, to give yourself the best chance of maximising your outcome. It's an exercise that has its own rhyme and rhythm, like any other. Some people are better at them than others, but you just need to be well prepared and systematic and do your best. Can't ask more than that. Come along prepared on the day. And very important that you are very clinical with yourself in terms of time allocation. You will see that different questions have different mark allocations. Then you need to decide how much time you're going to devote to those questions, and you need to be clinical about how much time you devote and no more, and then move on to the next question. Okay, and that's the way you just need to tackle it, and be systematic in your strategy of undertaking the question that you're facing, and bring to bear those skills that you've been developing and fine-tuning as you've been going along, and suggestions that I've made from time to time around improving that, and the comments that I've given you on your assessments and so on. Different nature, different type of exercise, the invigilated exam, of course, but problem-solving questions, answering policy-style questions, the process doesn't change. It's just the time limits are different, the circumstances of the exercise are different, and it's just the way it is, folks. We've all been through that, and that's the way it is, for the time being, at least. Accrediting bodies require us to have invigilated exams. So there you go. Right, so we are now marching on to mortgages. Now, there's a couple of questions that are set down for tonight. I'm not going to do both of those, really. I don't think we need to. The one I'm going to focus on is the question 4. Question 4 actually links back to the information in question 3. So that's question 4 is on 149 of the Q&A book, and it links back to Q3, which starts on 144. Now, just a couple of opening remarks about the law of mortgages, and it's interesting. I mean, this often comes at this stage in the course, and everyone's a bit over everything at this stage, but and you've seen that the concept of the mortgage, interestingly, has, and this may have surprised you or not, I'm not sure, but it's actually been a bit of a recurrent theme in various ways over the course of the unit. And we saw it back when we looked at Torrens title in different ways, both in terms of indefeasibility, in terms of the nature of what's in the mortgage and what that indefeasibility can relate to. You even, in the second assessment question there on unregistered interests or instruments, surprise, surprise, 2 mortgages again. You had in the first question, you were dealing with the first assessment, you were dealing with mortgages as well, national mortgage form. So it is, an instrument and an interest that keeps injecting itself into the discussion, if you like. One of the reasons for that is, it may well be obvious, but is property transactions have to be financed. And it's most typically the case that people don't have bags, brown paper bags full of money. If they do, maybe they're a bit suspicious anyway, that facilitates these property transactions. So they need finance. They need to work with financial organisations, with banks, with lenders to help facilitate the process of purchasing property and so on. So that's where, of course, the instrument of the mortgage comes in, because it is a security interest in the land. Now, the interesting thing is that the concept of the mortgage has a long pedigree, because this idea of needing finance or money to help acquire property or do something with property, it's not new. It's been in existence for time immemorial, in a sense, okay? But if you go back all those decades and centuries, of course, we didn't have large financial organisations then. We had wealthy individuals, or maybe in some cases relatives, that would extend finance and whatever, and then set up a basis for how that was to be secured. A bit like in my view, question 4, the unrealistic scenario that's posed there, almost like a typical law school type situation, where you've got an individual who's related to someone loaning, this bundle of money, and then surprise, surprise, despite being related to the person, completely legalises the whole thing and puts in place all of these mechanisms, as you do if you're loaning money to a family member. That's what you do, isn't it? You sort of go through all that formality. Well, it's a bit unrealistic in my view, but it's designed for a purpose. But going back in history, of course, that was something that did take place. And that's not how things work today. Mostly people are funding their property transactions by borrowing from large organisations, banks and so on. And then those funds, the borrowed funds that are helping to facilitate the property transaction, are being secured by the lender getting an interest and a security interest in the land. Now, in Queensland, as we've said, we have all private freehold is Torrens title. So in Queensland and in other parts of Australia, where today, mostly in other parts of Australia, sometimes there's another type of mortgage, but we're mostly talking, and in Queensland we are talking about Torrens title mortgages in the context of private freehold. Now, a Torrens mortgage operates in a different way to a general law mortgage. In a Torrens mortgage, the registered proprietor, who is the owner of the land and who is purchasing the land, if that's what's taking place, continues to be the owner and becomes the registered proprietor on registration of the transfer of the land. The mortgagee, that is the entity that extending the finance, the lender, only gets a security interest in the land. So the owner of the land, the registered proprietor, is the mortgagor and the borrower, and the bank, finance company, whatever, is the lender and the mortgagee and getting a security interest. There's two sets of transactions actually taking place. There's a loan contract between the lender and the borrower, and there's also regulation in place in regard to consumer transactions today, consumer credit legislation, as you will have seen the materials if you had a look. And then there's also the mortgage, which is a property law relationship between the mortgagee and the mortgagor. Now, a general law mortgage, in some places referred to as an old system title mortgage, because it was the type of ownership system that predated the Torrens system and still exists in tiny pockets in some parts of the country. And a general law mortgage, which was where mortgages started, is quite different. So what happened was, if someone was buying land, or if they had land and they wanted to get finance to do something, and they went to someone, and this person, historically it would have been a person, wanted and said, okay, I'm happy to loan you money, but I'm going to enter into a mortgage with you. What actually transpired was the title in the property was conveyed to the mortgagee for the duration of the mortgage. And that was common law. And the borrower didn't have title for the duration of the mortgage. Then there was an understanding and recognised that the lender would, the mortgagee would reconvey the property back once the debt had been paid out. Now, again, historically, sometimes they stopped, mortgagees stopped doing that. And so then equity got involved to ensure that they did the right thing. And they equity recognised what it called an equity of redemption, which meant that the mortgagee had to reconvey the land at that point. Now, there's some discussion in the chapter 11 of your casebook around this idea of equity of redemption. And there's also something about what's called clogs on the equity of redemption. And this comes out of the general law mortgage environment, but it still has some application in the context of Torrens title mortgages. And I'll comment on that shortly. And you can make some, just note it somewhere in your casebook or somewhere and have a look at it. But we're looking at a Torrens title mortgage. We're looking at a situation where the registered proprietor has the ownership of the land and the indefeasible title. And is the mortgagor borrowing monies. And the mortgagee is lending the monies, but is getting a security interest via the mortgage in the land. Now, the mortgage itself is an instrument, as we've seen earlier in the unit. Torrens title mortgagees can register their interests on the system, and they can then be encumbrances on title, most typically. We've also seen situations where they're unregistered, and then how do we deal with that? But if they are registered, then they're noted on title, they're there, public search of the register reveals them. Issue then is that the mortgages themselves have covenants and terms and provisions. Where are they to be found? How do you locate those? We looked at that a bit earlier in the unit as well, around infeasibility. And so the nature of those covenants is important. But one of the critical ideas that then becomes important in this area of the law of mortgages, which we haven't really touched on up until now, even though some people wanted to try and tie it in the assessment. Question 2 wasn't really relevant, but they wanted to tie in information about the law of mortgages. But it's about the rights of the mortgagor and the rights of the mortgagee. Now, essentially, the rights of the mortgagor is about circles around this idea of the equity of redemption, and that there cannot be what's referred to as clogs on that equity of redemption. Now, that came out of a general law context. You might say, well, why is that relevant in the Torrens system? Because there's no conveyance or reconveyance of the land. That's not taking place. How it works with regard to Torrens title is that where the debt's been paid out, then the mortgagor has a right to require the mortgagee to discharge the mortgage so that the land then becomes unencumbered. Now, interestingly, as a matter of practice, mortgagors today often decide not to discharge a mortgage when they continue to be the registered proprietor of the land, because from a practical point of view, not a legal point of view, but from a practical point of view, they might want to decide to take out further finance in the future over their property. And if they've got a mortgage facility on foot, it means they don't have to go through the whole process of mortgage approval and so on and so forth. Okay? That's from a practical point of view. The legal consequence of not discharging the mortgage is that the title is still encumbered by that mortgage. That's the property law consequence. And if they want to sell the property, they will find and discover, maybe to their horror, that they've actually got to go back to their mortgagee and consult them before they undertake that step, even though the debt's been repaid. But that's where we get sometimes this rub between matters of practicality and how people do things out there as a matter of reality, as opposed to the legal arrangements. So that's dealing with the mortgagor's rights. And as I say, a little bit more, we'll just touch on, I want to refer you to a case about that idea of equity of redemption and clogs on equity of redemption and so forth, just briefly, and bring it to your attention. But the big idea, big ticket idea in this area really is about the mortgagee's rights. Okay? And the mortgage, and this is what this question is, and we're going to focus actually on scenario 2, because that's the most practically relevant one, even though the first one is the one that is probably more in popular imagination. And I mentioned this, I think, in my lecture, that the mortgagee's rights fall into 2 categories. Okay, what we're talking here, obviously, of course, is the mortgagor is in default on the loan. They're not meeting their obligations under the mortgage. So the mortgagee wants to come in and do something to exercise their security rights with regard to the property, so that they can satisfy the debt that's outstanding, not being paid, whatever. So there are 2 chief remedies that they can do. They can exercise their statutory right of sale, power of sale, under the Land Title Act. And there's provisions in the Land Title Act and also in the Property Law Act in relation to mortgages. And they have to follow a certain process and tick certain boxes in that process, and be very careful about how they undertake a mortgagee sale, because it doesn't operate or function in the same way as a standard regular sale transaction, not at all. Okay, the mortgagee has to be very careful. And if I was to give you a question around this area, this topic, that's the sort of thing that I'd be testing, because it's very important to have a grasp of that. Now, that is the remedy that mostly today the mortgagee wants to exercise, the power of sale, and it's a statutory right under the Torrens legislation in Queensland, the LTA. There is another type of remedy that they can exercise, which is the one that's, what I say, is in the popular imagination, and that is their right of foreclosure. We hear a lot of discussion, a lot of comment about banks foreclosing on the mortgage. And it appears in general discussion, it's even appeared in music, it's appeared in theatre, it's appeared in all manner of forms and manifestations. Right? The idea of foreclosure, which still exists, it comes out of the general law environment, but it has still recognised under the provisions of the Torrens system. It's where the mortgagee actually takes title in the property. You can well imagine why that's not the first port of call for most mortgagees today. You can imagine if the big banks, we had defaulting loans by mortgagors, and all that they could do was actually become the title owner of these properties. Well, that's a great benefit to them, isn't it, in terms of satisfying their debt. That's what they're about. That's what they want, right? So that is possible. They can exercise their rights of foreclosure, but it's not the typical remedy at all, as I said, despite the fact that it's out there in the popular imagination. And it's really the right to exercise the sale of the property, the mortgagor's property, that is the pathway that they use. But what's really interesting about this is that under a mortgagee sale, the mortgagee actually has duties that are owed to the mortgagor, who is the owner of the property. Now, that certainly isn't the case in a standard sale transaction. The seller does not have duties to the incoming buyer, okay? The buyer often has to make their own inquiries and whatever. Some matters will be revealed by a seller, but as required by legislation. But in the mortgagee sale, the mortgagee actually has duties to the mortgagor. Now, the situation becomes even a bit more complicated when we actually have a sale and the mortgagee hasn't actually followed due process in effecting the sale. We then have three parties involved. We have the mortgagee, the mortgagor, and we have the incoming purchaser. And where the mortgagee hasn't fulfilled its obligations and its duties correctly, then this raises issues about Usman, we'll see you, but the recording will be available in due course. The mortgagee has to do things in a certain way, and then there are questions about what can the mortgagor do if, for example, the incoming purchaser has already registered his interest. Well, transaction may have concluded, and you can imagine today electronic conveyancing, right? The process is very quick in terms of lodgement of the transfer. It all happens electronically through the PEXA electronic workspace. And there you go. What happens then? So there's some law around that, and that's the environment most typically that is relevant in this context of thinking about the law of mortgages. Yeah. Right, so we'll turn then to the problem question. Now, you need to start by reading some of the information in question 3, which is on page 144, and then come across to question 4 on page 149. And as I said, we're just going to focus on scenario 2, which deals with this power of sales scenario or dimension. All right. So, give you a couple of minutes just to have a look at and have a brief read through that question 3 information, and then over onto question 4. As I said to you before, in my view, it's a bit unrealistic in being set up, in terms of someone and their uncle, and then the uncle entering into all these very clinical, legal, I mean, that's a bit, it's just been concocted for the purposes of the exercise, and I get a bit frustrated at things like that because it doesn't smack of reality, right? But anyway, it is what it is. So we'll just have a look at that. Can you see, for example, on page 144, the interest the uncle's charging on current interest rates? Seriously, I mean, this must be the best uncle in the family. So not only charging 7%, but also there's a penalty rate there if you're late in payments. Anyway, just have a look at those the facts there, folks, and then we'll just have a chat. All right, so hopefully you've had a bit of a look through that. So we've got, you know, these couple that have this property, the facts reveal that they're joint tenants. Can I just say, where the factual information says something and states something, you can take that as a given. So again, go back to the assessment, right? I thought the information was quite clear that the second mortgagee had, for example, lodged a caveat. I thought that was pretty clear on the facts. If they've lodged a caveat, if they've done something, you don't have to go through the process of determining whether they've done it. It seems to be pretty obvious. They're clear that they've done it, right? There might be issues about its legitimacy, I suppose. There might be issues about its enforceability, but you don't need to actually go through and establish that it's actually happened. If it says it's happened, okay? You can take it as read. So you need to discern here what it is you need to be focusing on and how you need to be structuring your answer. Okay, so that's just a general point, not in relation to mortgages, but generally in terms of problem solving. Okay. Don't also, just another little tip, don't forget that I think that, and I've mentioned this to you before, but in property law, doing a timeline can be quite helpful because the events occurring at different points in a time cycle of a scenario can have significance, and also trying to work out, you know, the different characters and how they're linked together, and some little diagram that might help you do that in a more complicated situation. All right, so we've got, in this situation, we've got this couple, Susan and Jack, and then they've got this property, and they've then borrowed some money from their uncle to do various things, and he's required a mortgage. He's being very particular about his legal rights here. He's registered his mortgage, and he's got all these interesting clauses in his mortgage, right? He's obviously best uncle on the block, given how he structured his security interest in his niece and nephew's property, including the interest that's being purported to be charged, including matters with regard to higher rates if there's default, and so on. So that's a background information about the situation that you need to be aware of for the purposes of then looking at question 4 on page 149, and we're focusing on scenario 2, which is about this idea that he wants to, where there's been default on the loan, he wants to exercise his power of sale, and how that can take place. And you're given specific information, you can see over from 149 to 150, as to how that's various steps that are being undertaken there in terms of appointing a real estate agent, how the property is going to be sold in terms of by public auction. There's information about who's running the auction and price, and the advertising the sale, time of information there about when the sales take place, both in terms of the day, the time of day, the day of the week. You're also given information that it happens to be on a Brisbane show day, which would suggest a public holiday, and then you're also then told that Brisbane Realty then let by Les, a company partly owned by Leicester, to put in the winning bid. So you've got another dimension there of this idea that there's a connection between the mortgagee and the purchaser. Okay, obviously raising that concern about the sort of type of transaction we saw in the Terrigal case back when we looked at that earlier in the unit around unregistered interests and priorities. And, where there's a connection, of course, issues around transparency, issues around probity, was it a legitimate transaction, and so on. So just going to the discussion around scenario 2, which starts on 151, you can see that there's reference immediately to the provisions of the PLA. Now, I'm just going to screen share that with you. So it's important to remember here that we've got provisions in the PLA, and we've also got provisions in the LTA in regard to mortgages. We'll have a look at those just for a moment. So what we've got here is Part 7, is dealing with mortgages, and you can see that Section 84 is and Section 85 and 86 and 87 quite important in this process of a sale. But we'll get to look at 84 first. Now, what we can see here is that the way in which the sale takes place is specified by, and the process is specified by the legislation. So, and it sets up the requirements in terms of what needs to be undertaken and how that's to be observed. Now, the degree of how that's regulated in Queensland under the Queensland legislation is not identically replicated in all other jurisdictions. And the argument is that actually to some degree it's more stringent here under these provisions. So that's something to be mindful of. Notice also that there's reference there in sub 4 to the Land Title Act. So you've got a correlation here between the provisions. Okay, important to be mindful of that. And I'll just take you across to the LTA. So here we are with in Part 6, Division 3 for mortgages. Some other areas may arise as well, but just be aware of that. Okay. I'll just stop screen sharing that. We've lost Nicole too, so we're the last of the last, folks. Last of the last. We're not going to go on too much longer. I want to run through a few things with you, and then we'll finish up. But so that's something quite important to remember, is that the legislation here is governing the process, and it's quite stringent in terms of what the mortgagee must comply with in exercising its rights of power of sale under the legislation. And if it doesn't comply, then the sale in the end can be avoided. Now that's interesting because it can also have implications for the purchaser incoming. Okay, and I'll just, on that issue, I just want to Some discussion, if you turn, for example, in your casebook to page 1134, yes, that's 1,134, folks. It's starting to sound like a person selling a car, isn't it? Just $39.50, right? $39.50, is that what it is? $39.50. 1134, 1,134.
Is this the saddest, Michael?
No, I'm not. No, I'm not. I'm a kind-hearted soul, Peter, kind-hearted soul. So I'm looking at paragraph 11.90, and if you can just see down there, it's the second sentence, Queensland provision states that it is the duty of a mortgagee in the exercise of the power of sale to take reasonable care to ensure that the property is sold at the market value, 85.1. It also imposes additional requirements on the mortgage over residential land where the mortgageor's home is on the land, including a requirement to advertise, to obtain reliable evidence of the property's value and to sell by auction, 85.1 capital A. And when we come back to the facts, right, so this is where, you know, this scenario is set in Queensland. It's picking up on these features of the legislative scheme. So if we're talking about a residential dwelling, we need to have an auction sale. We need to have market value. So there's information here about the actual winning bid. Does that connote with the market value, or we're told that the reserve price was the market value, but in the end, the winning bid got more than market value, but not much more. And as we know, on a rising property market, at a public auction, the value can increase exponentially in the wink of an eye. Right? A property that is worth $400,000 one minute can suddenly, miraculously, be worth $500,000. Where does that extra $100,000 come from? Who knows? Who knows? But auctions have that magic about them. So I want to point out that's a discussion about the Queensland provisions being more stringent. It's also interesting if you come across on 1135, first paragraph after the quotation there, asking what is the nature of this obligation, and asking, is it a negligence test? And there's some case law on that. Is there a difference between recklessness and negligence? You might recall thinking about these when you did your tort law studies. Well, we are talking about duty of care here, right? But it's within the statutory scheme, okay? So just need to be mindful of that. And so basically there's a need to work. You can see, if you go back to the Q&A book over onto page 152, you can see that there's a working through these various features of the sale process, right? Appointment of a real estate agent, advertising, timing, sale price, and so on. And they're the dimensions of working through the process that is needed. Now, if we've got a buyer, now on the facts, we've got a winning bid, and we've got that winning bidder has actually signed a contract, okay? So that then brings in the dimension of the purchaser. What are the obligations if there's been non-compliance with due process by the mortgagee? This takes us to the important case on the protection of the purchaser which is Forsyth and Blundell, 1973 High Court, on page 1140 at paragraph 11.99 capital C. Now, I don't want to go into all of that detail, but you can see on page 1145, comment on Forsyth and Blundell at 11.101. As Forsyth and Blundell demonstrates, the court will set aside an improper sale, notwithstanding that the purchaser entered into the contract without notice of the impropriety in the exercise of the power. In the absence of statutory protection, the position of the purchaser who does not have notice of the impropriety until after completion of the sale is not improved. Now that's interesting, isn't it? Because previously we've said that the purchaser under a contract of sale has something akin to an equitable right. Well, we've seen that and we've discussed that previously. But here the question is being challenged by this situation. And a bit further down, there's reference to more recent case law, which I've provided you with in different places. Queensland's Purchaser Protection Provision, Section 87, was applied in Tenderis and Ogle, which is a 2004 Queensland Supreme Court decision. We just come back to Section 87. That's of the PLA. I'm just going to go back to the Property Law Act. So you can see here that even though we're dealing with Torrens land, the sale process is being regulated by provisions under the PLA, not the LTA. Because the LTA is concerned with the processes of registration and the consequences of registration of the mortgage and so on. What we're looking at here is powers that the mortgagee has under its mortgage instrument, which are dealt with in the PLA. This is Section 87. Where a conveyance is made in exercise of the power of sale conferred by this Act, the title of the purchaser shall not be impeachable on the ground that no case had arisen to authorise the sale, or that due notice was not given, or that leave of the court when so required was not obtained, or when the mortgage was made before or after commencement of this Act, that the power was otherwise improperly or irregularly exercised. So what's said in Forsyth and Blundell is now qualified by the statutory provision in Queensland, okay? And it does provide that purchaser with protection, okay? So that's important to recognise that. I want to go back. There's discussion of the connection between Forsyth and Blundell and Section 87 over on page 153 to 154 about whether the sale can be set aside or what. You can have a look at that. That's in the Q&A book. I just wanted to go back to, so this problem question is about what the mortgagee can do in exercising its power of sale, as we've been saying. But I just wanted to return to that point about, which I raised earlier, about equity of redemption, and which is the right of the mortgagor, or the remedies of the mortgagor. And I just want to point out something to you, okay? So, the remedies of the mortgagor and this discussion on what's called the clogs on the equity of redemption starts on page 1191. Now, this idea, as I mentioned earlier in my opening remarks, comes out of general law. I'll just stop screen sharing that. But is relevant to Torrens mortgages in terms of the right to have the mortgage discharged where the debt's been fully paid out. Okay, so that's how this idea resonates in a Torrens context, if you like. Okay, but what I want to point out to you is that idea of thinking about, so the equity of redemption is in general law was the right of the mortgagor to have the property reconveyed back to them on payment of the debt. That resonates in the Torrens system in terms of the right to have the mortgage discharged. Okay. The idea of clogs on that mean, making that difficult or somehow interfering with that. Right? So we've got a couple of cases here that look at that. Interestingly, not in the context of land, but in the context of shares, okay? But the ideas are still relevant for us in the context of land. We've got the Westfield Holdings case, which is at 11.50C on page 1100. 1100, which is a New South Wales Supreme Court decision by Justice Young. Now, you don't need to read, into that too much, but one of the points that comes out of Peter Young's judgment is that he's looking at mortgage in relation to shares, not land. Okay, we acknowledge that. And there's something there that enables them, the mortgagee, to be able to purchase the shares where there's been a default on the loan. But one of the points that Justice Young raises is, this idea of equity redemption and clogs on equity, it sort of comes out of history, and does it really work in modern commercial situations? I mean, can't commercial parties, come to, what they've agreed to, will accept and acknowledge? And he basically, that's the point he arrives at, and it's saying that, if you can see on page 1102, just that there's one paragraph there just toward I think it's the second last paragraph. There does not appear to be any commercial reason why, in 1992, the court should invalidate any transaction merely because a mortgagee obtains a collateral advantage or seeks to purchase a mortgage property. Quite obviously, equity must intervene if there is unconscionable conduct. Again, equity must intervene in the classic case where it can see that a necessitous borrower is not, truly speaking, a free borrower. So he is making some observations about, when equity should intervene. I think the point about unconscionability resonates with the thrust of equity in the modern period, being concerned about as that being a basis for its intervention, generally speaking, not universally, but generally speaking. But he's also trying to say, but look, we have to understand commercial reality today. When we're looking at doctrines that have come out of history and are still part of our law, we have to look at what is the situation today in commercial practice, if that's the environment we're looking at. I'm not talking about an individual consumer transaction here, but we've got commercial parties. Now, that's a decision in New South Wales, seems sort of to make sense, seems to be pragmatic in its approach, but it's also mindful of the role that equity plays, which is good. That was decided in 1992. We then have, in 2014, the Sun North Investments case, which is a decision of the Queensland Supreme Court, where we also had an issue with regard to shares, again, not land, so shares. And we also had there an option to purchase those shares by the mortgagee if there was a default. And in this case, the court was looking at this idea as well, and the equity of redemption and the clogs on the equity of redemption. The court in this case took a very different view about the whole matter. So we're dealing with same scenario, shares, we're dealing with a commercial situation. Here is what the court said. Okay, so over on page 1104, here, if the option to purchase is made as part of the mortgage transaction, an application of the rule against fettering the equity of redemption compels the conclusion that the option was void because it was given as part of the lending transaction and had the effect of purporting to extinguish the plaintiff's equity of redemption. It's totally non-negotiable on this. And in the end, he actually finds that it was void at the outset. On looking at the approach in Westfield, which I've just outlined to you in general terms, he actually says, over on page 1105, the failure of the Westfield approach to give determinative weight to the inherently conscientious nature of the transaction as an automatic foundation for the intervention involves a departure from established law. And over on page 1106, which I decline to follow. Now, why am I pointing these cases out to you, particularly in a non-accessible topic? You might be saying it's a long bow, Michael, and it's 9:30 at night. What's going on? You're trying to get every ounce out of this course. I think there's interesting observations there which you can, if you got the time, just reflect on a little bit about the role of equity, right, in law generally and in property transactions and property law in particular, and how it meshes with the realities today. So that's about particular application with regard to this idea of the equity of redemption. And the case law is drawn from examples outside of land law. Yes, that's true, but there has some relevance in the context of Torrens land and mortgage situations. But the bigger point for me that comes out of looking at those cases is this connection between the role of equity on the one hand and the circumstances of commercial reality and how these work together. Now, consumer transactions are different, and there are other protections in place in consumer transactions. We have the Consumer Credit Code, which needs to be adhered to in those types of transactions. But in commercial transactions, right, and as lawyers, we are often more involved in those types of matters where disputation arises. Yes, as lawyers, we can be involved in standard sale and purchase transactions for residential clients. Yes, of course. But where disputes arise, we often are more involved in commercial type situations. And I think it's interesting to reflect on this connection between equity and commercial reality, if you like. There's not a complete answer to this, but it's interesting that we've got different views about, does equity prevail absolutely and it's a non-negotiable, or do we have to find some accommodation here with the changing circumstances and the changing commercial environment within which commercial parties are operating and functioning? And I think that for my own sake, I think that, we do need an accommodated position. We can't have absolute yes, no. We can't be strictly adherent to doctrines merely because they exist, where the circumstances are different and the realities are different. Okay, so that's just something to be aware of. And the other part of this question dealt with the less used remedy of foreclosure. You can have a bit of a look at that, but it's less used, as I've said. The main avenue is the power of sale. And the other question, which we're not really going to pursue, really was touching on the idea of the national consumer credit provisions and how they work and what role they play in the process. You can have a look at those as well. Right, folks, we're at the end of the end. Law of mortgages. And that's it. I don't have anything more to add to that. But we'll have another class next week and have a exam, focus on exam preparation and a bit of a wrap up and a send off and all this sort of thing. So we won't do that tonight with only 3 of us, 4 of us, including me. But that's the end of the substantive topics. Okay. And we've been on a long road together since March. But there we are. Mortgages, folks. Done and dusted. So thanks for joining. Thanks for staying for this section. And as I said, there'll be class next week. Come along with your questions and any issues you have in thinking about the exam. So until then, it's good night from him and it's good night from me. Good night.
Good night, Michael. Thank you.
See you. Bye.
Night, Michael.
Night,
Peter.
Bye, Peter.
Bye, Sarah.
Bye, Sarah.